So my name is Bill Barton, and I'm one of the directors here at Barton Legal. We specialise in construction, and I say this Zoom webinar is intended to provide you with hopefully some information, some learning, and some top tips and skills. We normally have 50 or 60 different countries attending. So the purpose of this is to bring you together and to make sure that we all learn from different experiences. We have a common thread by attending, and I hope that the communication and collaboration is of interest to you. I'm delighted to introduce Kim Franklin QC first, a brilliant barrister. She's industry recognised specialist in the sectors of construction, engineering and infrastructure. Kim acts predominantly as an arbitrator now, dispute board member and adjudicator, resolving disputes arising from complex projects in international arbitration, dispute boards, and as a UK construction adjudicator. There's so much information, I have to read it. So, you know, this isn't off the top of my head because Kim and Gabriella have so much background. So Kim is also a chartered arbitrator, credited with 4 different dispute panels. So TEXA, CIARB, TECBAR and REBA. And additionally, she's been appointed to numerous ICC, ADCCAC and DIAC arbitrations in the UK, UAE, GCC, acting as sole arbitrator, party appointed tribunal chair. Wow. You know, as I said, I need a breather after all those accreditations. Due to Kim's amazing and incredible international reputation, she has spoken at and panelled numerous conferences, so you may well have seen her over recent months, both in the UK and internationally. She regularly contributes as editor of Construction Law Journal and has written many legal commentaries for also the UK Architects Journal, as well as speaking at SCL and CIARB events. Furthermore, yes, there is more. She's a key figure and I think role model in promoting women in dispute resolution and arbitration. Kim was described recently by Chambers and Partners in 2021 as, and I quote, very sharp and commercial, but also pleasant to deal with. What a lovely thing to say. Something which I think all of those who know her would thoroughly agree with. There are, of course, more women in construction than when I started many, many decades ago. And I think the fact that we've got 2 amazing women with us today is a sign that more women are coming into and hopefully will follow Kim's and Gabriella's footsteps. But I think it's duty bound on all of us to encourage more women into the broader industry. So I'm also thrilled to introduce Gabriella Gálik, another one of our international star speakers. Prior to being a founding partner at Hungarian law firm KCG Partners, Gabriella was a senior associate at another international firm, Gálik, and is now an acknowledged real estate transaction specialist with a vast experience in industrial development, construction law, infrastructure, and other major infrastructure and construction projects. With her doctorate in law, she's worked on many high-profile M&A commercial deals and also advised on larger scale operational processes such as restructuring across an impressive array of industry sectors. She has expertise in engineering consultancy and is very adept at using a variety of FIDIC forms, and is also an expert in the field of industrial development, as well as a certified tax advisor and mediator. Cripes, what a lot. Gabriella has been described as always proactive, super accurate, and excellent in communication, a simply brilliant professional, and that's another quote. So we are very fortunate indeed to have them both with us here today. Today's first presenter will be Gabriella. So, and it's not only a really beautiful, great presentation, but there's a little quiz running through it as well. So you do need to pay attention with some very beautiful buildings. I'm afraid that in the middle, you then get me just for a couple of minutes with some of my top tips for adjudication. But then thankfully, Kim comes along, lifts it back up to the stellar level that it was with Gabriella, and will give you brilliant advice and guidance on how to win an adjudication, which is after all what you want. So Caitlin, if we can now hand over and start the presentation And thank you very much. And if we can go to the next slide. And the next one. And I'll hand over to Gabriella.
Thank you, Bill, for the nice introduction. And I think we can move on to the next slide. And the next slide. So in my presentation, I would like to give you an overview about the general Hungarian economic environment, then the conditions of participating in constructions by foreign companies. Then I will have a few words about the typical contracts and securities, and finally, the main reasons for disputes, and I will present two special Hungarian legal instruments for solving these disputes. But before starting the real presentation, I would like to invite you for a quiz where I will show you 5 visualizations between the slides. There will be visual plans about signature buildings planned for Hungary, and your job would be to make a guess whether these are visualizations of real buildings that have been constructed in Hungary or being under construction, or only ideas that will never be built. And you can use the chat panel for this purpose. So we can move to the next slide, which will be the first quiz question. So please give your idea whether this is a real building or only a plan which never will be built. So I will give you some moments and then we can move to the next slide with a map to show you where is Hungary. It's in the very heart of Europe, physically and also in historical, geographical, cultural and economic terms. And Hungary is a full member of the European Union since 2004. The most important figures of the country are collected on this slide, which I will not read you, but I must talk about the minimum salary, which is still the second lowest minimum wage in the EU, trailing only after Bulgaria. So next slide, please. In the official Hungarian investment leaflets, there are 3 words to describe Hungary, why you can consider this place as an ideal location for investments. These are smart, ambitious, and competitive. What does it mean in practice? We have extensive road and railway transportation network, highly developed logistics and telecommunications infrastructure. We have highly skilled workforce, as we have prominent universities in Budapest and in the countryside, which serve as a knowledge basis for the companies. The company registration is an electronic procedure which is very quick, as it requires only a few days after registration, after filing for the registration of a new company. It's very important that we have very favorable tax rates for companies. The corporate income tax has a flat rate of 9%. You can hear it 9%, it's real, while the local business tax rate is a maximum 2%. And besides reducing the corporate income tax to this 9% flat rate, Hungary introduced new forms of cash incentive measures to enhance research and development activities and the realization of technology in intensive investments as well. So the government is really active in supporting new investments and extension of existing companies. The next slide is a quiz question again. So you can put your answer to the chat panel, whether this is a real building or an idea only.
I won't join in because I know what the answers are, Gabriella.
And I think all from Budapest know the real answer. So we can move to the next. So all in all, the environment in general makes Hungary suitable for any kind of development project. We have discussed the highly developed infrastructure and the cheap labor force, but the cheap land prices are also important factors. The average square meter price of an agricultural land is less than €1. Although it's a very complicated and a little bit longer procedure to acquire agricultural lands for investments, and the final costs will not end at €1, the prices are still very favorable in the countryside. And it's very important, it's a very important learning from the beginning of the pandemic that it has strategic importance for both the companies and the states to have the manufacturing capacities within the border of the country, or at least in Europe, instead of importing everything from China or other third countries. So this is why large companies are considering now relocating their manufacturing capacities to Europe. And the Hungarian government tries to attract Hungary for this purpose. And in the next slide, we have collected those significant companies who are already in Hungary. More than 40 of the world's 80 largest multinationals and many of their suppliers have established a long-term presence here, benefiting from the advantageous location, qualified suppliers, and from an advanced business infrastructure. The Hungarian government provided a large amount of non-refundable aid for major automotive companies and allowed the highly environment polluting tire manufacturing plants to be located in the country, which now is continuing with a slightly different additional direction. With the emergence of electric cars, many Asian companies, mostly Korean and Chinese, are building their automotive industry related battery plants in Hungary with governmental subsidies. It is also a governmental goal to become an advanced manufacturing and innovation center in Europe by further increasing the number of investments, generating high added value. After these numbers, you will have a quiz question again in the next slide. So you can use the chat panel to decide whether this is a real building or a plan only. It's a nice picture, in any case.
I'd pay for that to be built.
Okay, I think we can move to the next one. So after presenting the general Hungarian business environment, I would speak about the constructions in Hungary. If a foreign company wishes to participate in Hungary in a private construction project, there is no requirement to establish a local company or a joint venture here. But if someone plans to participate in several projects or for a longer term would stay, it may be advisable to establish a local company for this purpose. However, if a foreign company wishes to participate in a public procurement, there are certain territorial requirements, such as the bidder must be originated from the EU or these other countries, which are listed on the slide. UK is there, Bill, so that's very fortunate, but China or Russia are not included in these countries. And regardless whether the project is private or public, there are mandatory Hungarian laws which the foreign company must be in compliance with. As to the design, it's important that the architectural and engineering planning activity may only be performed by the members of the relevant Hungarian professional chambers and having design license and being listed in the design register. So if a building project is designed by a non-Hungarian or non-registered designer, the design works and the documentation have to be localized. In this process, designer having Hungarian license takes over the full responsibility for the design documentation prepared under non-Hungarian design rules or by someone who is not registered in the Hungarian chambers. And the documentation and the plans are controlled this way and redesigned to ensure legality and conformity with the domestic Hungarian regulations. And there are certain roles and positions for the construction process as well, which are mandatory. For example, the contractor company must employ a so-called responsible technical leader. And in certain cases, the client must use a construction technical supervisor. And both of them are natural persons holding license for such activities. And they are assisting and controlling the compliance with the applicable laws, one on behalf of the contractor and the other is on behalf of the client. We can move to the next slide. Now I will have a few words about the contracts. For large private projects, the developers prefer to use their own contracts, tailor-made for their specific needs and the project's characteristics. In certain cases, we use FIDIC contracts, mainly the 1999 editions, but we do not use other international contract templates. In public projects, also bespoke contracts are typical, but FIDIC red or yellow books are also used, especially in infrastructure developments or where foreign financing is involved. Typical securities are penalties, as everywhere in the world. The good performance guarantee and the warranty bond are bank guarantees. Good performance guarantees serving as security for the client during the construction phase, while the warranty bond after completion in the warranty period, which is typically 2 or 3 years. Retention money is usually paid to the contractor at completion, so it's not withheld in the warranty period. After these very dry details, we will have a quiz question again. I will give you some time to digest this picture, and you can make a guess in the chat panel whether this is real or an idea only. And I think we can move to the next slide, which is the disputes during constructions. The number of both financial difficulties and international late payments declined in the last couple of years. However, more than half of Hungarian companies suggest the introduction of new national legislation in order to solve the problem of late payments and to decrease the generally applied 60 or 90-day payment deadlines. Next slide, please. The Hungarian legislator intended to assure the financial performance of construction contracts and the proper payment to the subcontractors. So in 2010, the so-called project fund management regime was introduced in private construction projects. If the value of the construction works exceeds the limit of 5,350,000 euros, a so-called project fund manager must be appointed by the client. It can be either the Hungarian state treasury or a financial institution, typically a bank. The investor, before each phase of the construction work, must deposit the amount necessary for the performance of the construction works on the project fund manager's bank account and provide the fund manager with exclusive access to the account. Then the project fund manager participates in and oversees the payments of the works from the beginning of the contract until the closing settlement, following the final invoice of the contractor. In practice, the fund manager pays the invoices to the general contractor from the amount deposited by the client on the project fund management bank account. In case a project fund manager is involved, the subcontractors must be registered in an electronic subcontractors register, which is a part of the logbook opened by the general contractor. Then the fund manager's right to retain or separate certain amounts can be made for the benefit of those contractors only who are registered in the electronic subcontractors register for the given phase. In practice, the introduction of the project fund management regime helped to improve the payment culture during the construction, but certainly does not give a solution for all disputes, and especially in smaller projects where the involvement is not mandatory. Next slide, please. Another typical reason for disputes is the unapproved performance, which closely relates to the disagreement of the parties, whether the given work qualifies as additional work or overhead work. These are categories under the Hungarian Civil Code, where additional work means the work which has been subsequently ordered by the employer and became necessary, especially due to the amendment of the plans. Overhead work means the work which had to be done, but not taken into account in the calculation of the original contract price, and also the work that is considered essential for the completion of the works in a condition suitable for the proper use. Next slide, please. The solution that the Hungarian legislator introduced in 2013 for these kind of disputes is the so-called performance certification expert body. It is an organization which assists the parties in resolving design and construction disputes. The dispute can be raised either by the client or by the contractor, the subcontractors or the designer over the issuance of a performance certificate or the settlement of part of the contractor's fee or the drawdown of a bank guarantee. A three-member council of forensic experts decides on the technical performance based on the submitted documents and an on-site inspection, or decides on the extent to which the performance has been completed, and therefore the extent to which the remuneration is due to the contractor. In case of a bank guarantee, the council may declare the extent to which the drawdown is justified. The primary purpose of the expert opinion is for the parties to agree on the basis of the expert findings. If no agreement is reached, the claim can be enforced before the court based on the expert opinion with shorter procedural deadlines and under special procedural rules. The deadline for the preparation of the expert opinion is 30 days, which can be extended with 30 days in justified cases. So the expert procedure is completed in all cases within 60 days. In practice, this may be a useful procedure, but from the employer's perspective, it can make the concept of the bank guarantee practically empty. The main advantage of the bank guarantee is that the client may draw it down when it considers rights unconditionally, and the bank does not examine the underlying legal dispute. However, if the contractor contests such drawdown and initiates such procedure, the performance certification expert body must approve such drawdown, and it means that the client can get the money later or does not get the money at all if it's not approved. Of course, only if it goes to the court, and that's a new procedure again. But then the bank guarantee is not used or cannot be used. Next slide, please. As to the dispute resolution, Hungary is a small country and is a small market. It means that in large projects, the parties usually try to settle the disputes in amicable way. If it's not possible, ordinary courts or arbitration decide on the dispute, and there is no special court for construction cases, unfortunately. Mediation is more and more common, however, it's not really a part of the legal culture, not yet. I would say neither adjudication. Adjudication clauses are usually deleted from FIDIC contracts. This is why I'm really curious about Kim's presentation, how it works in practice. So we can move to next slide. It's the last quiz question. It's a beautiful plan again, and you can decide whether it's a plan, an idea only, or a real building.
A beautiful building.
In the city center, I have to tell you, it's planned for the city center, the very heart of Budapest. Okay. Finally, I would like to speak a few words about the pandemic, which was a real shock last year for all of us, but despite all of the effects, last year was a year of successful working capital investment in Hungary. Large amount of companies from the East appeared, especially from South Korea, China, Japan, responsible for 30% of the total projects. More than 10% of projects in terms of both the amount invested in and in the number of projects were investment in the food industry, which can be partly attributed to the epidemic situation. And although ongoing projects had to face some negative effects, such as the difficulties with the workforce and the supply chains, there were finally moderate damages in the construction sector last year in Hungary. And it must be mentioned, of course, that the Hungarian government is strongly supporting the construction industry with various tools, for example, by reduced tax rates for new residential buildings or developments in rust zone or rust zones, and also with special allowances for families and for remodeling. And the Hungarian government is a very active investor of the market by the construction of large stadium and road construction projects. Based on the forecasts, it's not a crisis, what the experts expect, rather a roller coaster. So we trust it will not be a huge one, only a moderate roller coaster. So I trust you have enjoyed this very brief presentation about my country and some legal solutions we have. And this presentation will encourage you and your clients to explore these opportunities, as Bill said earlier. And I will give you the solutions of the quiz. Next slide, please. So this is a real building in the Budapest Zoo. It's called Biodome. It is a really expensive state investment. The budget has been doubled or more than double now. It costs approximately 100 million euros at this moment. Next slide is an idea only. It's called City Hall Forum, and it was never built. And the next slide is a real one, which is under construction. It's called the House of Hungarian Music, which is a part of a large city park reconstruction project in Budapest. And it became the world's best public building after previously taking the award for the best public building in Europe at the International Property Awards. The next one is a surprise. It's a real building. It was built for the Milano Expo a few years ago, and it's also called as a shaman's drum in the press. And the last one is the Zeppelin building, which is a plan, and it was never built.
Wow.
So I hope you enjoyed the quiz.
Thank you very much, Gabriella. Some beautiful buildings. I'm very interested by the use of the fund manager. I wonder, people have to ask how expensive that is. The fact that you have no adjudication, obviously there's lots of scope for construction lawyers, and the fact that you have no specialist construction court. So lots of scope for construction consultants and the rest to get into Hungary. Caitlin, can I have the next slide, please? So I hope you've all really enjoyed Gabriella's talk. I should point out that my daughter lived in Hungary for a while, and even after much coaching, I could barely say 2 words of Hungarian. So I have to again compliment you, Gabriella, on your very good English. Next slide, Caitlin, please. Right, you now have me just for a couple of minutes. I've put this slide up purely because I'm only going to talk very quickly about 10 things about adjudication. There is a larger download that you will get that explains the process in a great deal more detail that you'll get tomorrow. But I wasn't going to bore you all, basically, with it now. So 10 things about adjudication I think you should all know before Kim will actually give you some really top advice. Parties can adjudicate at any time. Parties can only adjudicate if the contract is a construction contract. That's not always as clear-cut as it appears, especially in relation to construction operations, so biomass plants, power generation. There's a difficult sort of grey area there. It doesn't include domestic, but it could include domestic if you include it in the contract. The time frame is approximately 28 days. It can be extended to 42 days. It can, without the consent of the second party. I was involved in adjudication last year that ran for 6 months. So you can mold it to your requirements. It's really up to you how well you use it, I would say. The majority of adjudications concern payment. Well, there's a real surprise. Interim payments and final payments are the main ones. But you can also use adjudication for extension of time claims and delay. And my 5th point, a dispute must crystallize before an adjudication commences. So there are a lot of jurisdictional challenges with adjudication, and I can spend a significant amount of my time advising clients on setting up an adjudication because jurisdiction disputes are now a major issue. Parties are jointly and severally liable to pay the adjudicator's fees, meaning both parties can be pursued for those fees if one party, usually the losing party, doesn't pay. And if you're advising, do not forget to remind your clients of this. I've had an example recently where we were successful in an adjudication the other side have very kindly not paid the adjudicator's fees, and therefore my client's fairly upset about the fact that he now has to. Insolvent companies can adjudicate. There's a case called Bresco that deals with that. 8th, adjudicators must resign where the dispute has been resolved in a previous adjudication. So again, there are lots of jurisdictional challenges that can arise if there are a series of adjudications, because adjudication was intended to facilitate the flow of money and, to a degree, sort of resolution of dispute, but with the idea that it could be used on a number of occasions through a contract. Your notice of adjudication must be clear and must set out at least the following: a description of the nature of the dispute and the parties, details of where and when the dispute arose, the nature of the redress sought, and the names and addresses of the parties to the contract. Again, you would be surprised that there are a number of notices of adjudication that don't clearly set out exactly what a party is asking for. And in adjudication, you have a notice and you have a subsequent referral document. It is the notice that is the most important document. And finally, adjudicator's decision is final and binding, and can, and in my experience, will be enforced by the English courts. They really do not take kindly to people not listening to adjudicators. So that's enough about from me about generality of adjudication. What you now want to hear is Kim telling you how to win an adjudication. So Kim, over to you.
Thank you very much. Oh, there's a lot of feedback there. Can you hear me? Thumbs
yes,
up?
you're fine.
Yep.
You're absolutely
Terrific.
fine. Very lovely.
Terrific. Thank you. Well, first of all, thank you for the fabulous introduction. You're quite right. I am very keen to encourage women into dispute resolution. I was shocked, perhaps I shouldn't have been, by a statistic that apparently women apply for jobs only if they feel they meet 100% of the criteria. Men, on the other hand, apply for the same job if they meet, guess what? Guess what? Out of 10,
20%.
60% of the criteria. And women believe that their good work will be rewarded. And so they work hard and wait for recognition. And this is known as the tiara syndrome. So I see my job as just to dish out those tiaras. And if you are a woman, or you know one, a good one, and apparently behind every successful woman there's a man who's slightly surprised, get those tiaras out, dust them down, and get on with that job that you are ably qualified to do. So, and also, can I say what a pleasure it is to address you all around the globe by these modern means. I'd just like to say that I have seen the seals in Eyemouth Harbour. So not only do I know where it is, I've been there. But isn't this a fabulous opportunity with this global audience to reflect upon the benefits of the adjudication process? So could I have my first slide, please? So one of the great joys of adjudication is that it is the ultimate low-tech dispute resolution. Here we are with modern technology gathered together. But adjudication, which has been around for about 21 years now, has sort of got established into a bit of a pattern of behavior whereby the vast majority of them are conducted on a documents only basis. And whereas in the beginning the parties were keen to meet, they now tend to be avoided. Organising a meeting was always difficult. Arguments about when and where and who was going to be there and who was available and what was going to be said and what was going to be done with what was said. All that can be avoided if you don't have a meeting. So during lockdown, it's not possible. We have to get on with it on a documents basis. And there are more efficient ways of getting answers to questions. If the adjudicator has questions, they can issue a schedule of questions which the parties can take their time in answering. Those questions can be tedious ones, what's happened to page 3 of this document, to more substantial ones such as what is your case on causation. And the parties can reflect and give a substantive and considered answer. Site visits, well, they're always useful, but seldom necessary. I used to feel it was essential to go and have a look at the celebrities' villa if they had a leaking roof or problems with their swimming pool. But the truth is you can manage without a visit. And with adjudication, there's no need for these marvelous virtual platforms that we're using. The most high tech that you need is hard copy documents. And as long as they fit through the letterbox, then that's the beginning and the end of the procedural challenges. Post them if required. So could I have my next slide, please? The other benefit of adjudication is its flexibility. So there is a wide range of available adjudicator experience out there. You probably know there are 18 adjudicator bodies, A and Bs. Some of them are discipline specific, like Tech Bar, which appoints construction barristers only, but many of them are cross-discipline. And until recently, most adjudicators, the majority of them were quantity surveyors. Lawyers are now in the ascendance for the first time. And this does, well, I'm sure you've all got views about that, but it does mean that if your issues are of a legal nature, they're to do with contractual interpretation, or you want a difficult decision on causation or the measure of damages, for which a lawyer would be best suited, they are now available for you. TEXAR and the Chartered Institute of Arbitrators are probably the best known AMBs that have a cross-discipline panel. They also offer a range of experience. So TechBar have a very simple model where they have juniors, they have juniors and senior juniors, and they have silks. They have junior QCs and senior QCs, and they appoint them according to the complexity of the dispute. But if you want a QC, they're also available on the RIBA panel, on the TEXAR panel, and on the Chartered Institutes panel. Now, all of this is important for you as the parties, because parties can, and many do, choose their own adjudicator. And at least 10% of adjudicators are appointed by the parties. And anecdotally, regular adjudication users say they try to agree adjudicator even when the contract provides for an appointing body. They always have a go at choosing and agreeing their own adjudicator rather than leaving the appointment to the ANB. Adjudication also allows for a flexible timetable. So it's the statutory timetable is 28 days, which can be extended by the referring party by a fortnight if they wish to. And most decisions are given within that timetable, but it can be extended by the agreement of both parties. And I recently decided two disputes. One started in April and the other in July in 2019. And I gave decisions in both of those in February of last year. And that was all done by agreement. More recently, AMBs are offering low value schemes. Nearly half of adjudications are for less than 100,000, but increasingly complex claims are referred to adjudication. And it's worth remembering that in 2019, 17% of adjudications were for a value of over $500,000. So that's quite a sizable percentage. A current theme which is being considered by the various ANBs is whether more junior adjudicators should be appointed for lower value disputes. And this is under discussion. So the more experienced dispute lawyers amongst us will know that simply because something is low value doesn't mean that it's easy. In fact, very often quite the reverse. But nevertheless, the market may recognize that it's a poor use of resources to have an experienced construction professional decide a very low value dispute. And there is the other challenge, which is to encourage a wider diversity in terms of seniority of adjudicators into dispute resolution. So as Bill said, although adjudications traditionally used for valuation and payments disputes, it can also be used for declarations. And this is an increasingly common remedy in my experience. People want to know what their contract means. People might have a few questions about the force majeure provisions, the material adverse change requirements, the hell or high water clauses. They may want a decision as to a breach and the cladding cases that we've had in the UK, and the meaning and effect of the building regulations is a good example of that. Or they may want to know about the liability or the causation for a defects claim, for example, before tackling quantum. And something I've seen a fair amount of is if you have a PSI contract or project, which is very complicated, that goes with the territory, the dispute can be very large, almost unmanageable. One technique is to slice it up very fine and ask for a series of declarations from an adjudicator or two, or a panel. And this will be in support of a wider settlement strategy, of which the adjudicator was likely to be oblivious, but they are being asked to address a particular question, and then a bit like a deck of cards, the parties are stacking up the answers to see if it can help with the resolution of the dispute. And also I've seen adjudication used as a test for how a claim would fare if it went further in litigation or arbitration. And for that purpose, you really do want to have a lawyer, because it's most likely that if you went to court, it would be a lawyer who would be trying your case. And if you want to test the water, it's a good idea to have an adjudicator who has a similar discipline, a similar approach to the judge or the arbitrator that you might end up in front of. So adjudication's not cheap. It wasn't meant to be, but the truth is it isn't, but it's a lot cheaper than a trial. And anecdotally, I hear that it's by a factor of about 10 that your adjudication costs come in. And whether you see it as a benefit or not, it's true. There is no risk of paying the other side's cost. The only cost jeopardy is who pays the adjudicator. And under my terms and conditions, it's always the referring party. They asked me to decide their dispute. They can pay and then sort out the liability issues afterwards. So against that background, could I have my next slide, please? Once you've started your adjudication, how are you going to get the best out of it? Well, the first point is to be reasonable. So I would ask you to bear your adjudicator in mind. Let's remember they are all human. Some of them are women. They do not like being called dear sir. And most adjudicators have lives. So if you're going to ask them to do an awful lot of very difficult work in a short time, your main objective should be to make it as easy for them as possible and be nice to them as you do it. So be polite, be reasonable, listen to what they have to say and get their gender right. That would be my first tip. Remember, adjudicators aren't judges. This is true. They do not have the powers that a judge has in court. The civil procedure rules do not apply to adjudication. So there's no point asking them to do something that a judge would do. Importantly, adjudicators can't apportion liability unless the parties have expressly agreed that they can or that it's in the contract. And an adjudicator can't extend the time beyond 28 days. That is a matter for the parties. So if you want complex procedures or unusual sanctions, you need to agree them with the other side. And if you don't want to do that, then go to court. Be reasonable. Now, all dispute resolution depends on reasonableness. Key to adjudication is a reasonable timetable. So if your referral includes the digital equivalent of 20 files with charts and spreadsheets and experts reports and appendices, you have to recognize it's going to take more than 28 days for the adjudicator to decide your dispute. And if your claim includes 5,000 scheduled disputed line items, all of them worth about £75, have a think about how it is you propose the adjudicator is going to decide them. If you want the adjudicator to go through every one, again, it's going to take longer. I always think, how would you do it? What is it you think that an adjudicator has that you don't have? They are not superheroes. I do feel like Wonder Woman sometimes in the First World War trenches, but I do not have the rope of truth. So just have a hard think about how this dispute is going to be decided before you lob it to the adjudicator. And remember that strict timetabling demands can cut both ways. So don't require the other side to turn their case around in a sixpence and then ask for a whole 7 days for you to put in your reply. If you are very stringent as referring party as to timetabling, you can expect that it may come back to bite you and ruin your weekend. Adjudicators tend to act fairly. It's part of the job, and they may believe that what's sauce for the goose is sauce for the gander. Many believe that the adjudication process allows the referring party all the time in the world to prepare their case. So it does put the responding party at a disadvantage. The whole thing is going to be dealt with in 28 days. For most, the time the responding party will have is a fortnight to put their response together. And we all know from experience that rushed preparation results in lengthy, muddled submissions, and it doesn't allow for reflection, it doesn't allow for a summary, for analysis, or for reasoned response. We all know we can get a document out in a hurry. It doesn't necessarily help with the dispute resolution process. So I recommend a clear and a reasonable timetable from the outset. It's to everyone's advantage. The parties can allocate their resources, and it allows for considered preparation, which ends with a more efficient process. Could I have the next slide, please? Now, as Bill said, the adjudication notice is the key document. The referral is the really long submissions with all the lever arch files, with all the appendices, but it's the notice which defines the dispute. It's very important that the relief that you're claiming is in the notice. You can't realize that you've forgot to claim interest and lob it in your referral if you haven't included it in your adjudication notice. I said earlier that many parties now are turning to adjudicators for declarations rather than for money claims. If you want a declaration, word it with care. The longer and the wordier and the wider your declaration, it may seem very nice and all-encompassing and should cover all bases, but the harder it will be for you to prove. So I was asked to make a declaration that the responding party was in breach of contract and negligent because the works did not comply with the contract. Well, that seems very wide. What could possibly be wrong with that? Well, I wanted to know what contractual provisions were they referring to. This was a very big contract. Which ones did they say were breached? They have included negligence in this declaration. Is there a duty of care in this case? And what works? Well, it turned out to be a number of tower blocks. What were the prospects of a declaration covering a variety of different shapes and size tower blocks with a broad statement that they didn't comply with the contract? How were the contractual provisions breached? Where were the details of that? So word your declaration with care. And remember, as a referring party, you do need all the basics, the basic elements of a successful claim. And they are a cause of action, a breach, you need to prove causation, and you need to prove damage. And as referring party, you have the time and the facilities to do that. And if you haven't got those elements, you may not be successful. Another thing you're required to do in your adjudication notice is to say when the dispute crystallized. Now, this is not as easy as it seems. And increasingly, people say, oh, it crystallized sometime last year between January and December. And there's quite a lot of correspondence which relates to all of this. Well, now that, I may say, is not helpful. It requires the adjudicator to decide when the dispute crystallized. It's a necessary element of their decision. And if you have that wide gambit of dates, the adjudicator could find the dispute crystallized at any time during that year. And that would mean that any claims that have been made after the dispute has crystallized would not be within their jurisdiction within that adjudication. So some of your claims may be excluded if you're not specific about when the dispute crystallized. Could I have the next slide, please? Referring party should bear in mind the burden of proof. It has the burden of proving its case on the balance of probabilities with evidence. Now, it has been submitted to me in adjudication that the burden of proof doesn't apply to adjudication. And this is a bit of a recurring theme, that somehow the rules don't apply to adjudication. And if you're a stickler for things like the burden of proof and for evidence, then you're over-lawyering the process. This just goes to show that the whole thing's been hijacked by the lawyers, which was never the intention in the first place. Well, you may be of that view, but let's take a pause and a step back. Adjudicators are required to reach their decision in accordance with the law. And absent any agreement to the contrary in the contract or in the adjudication itself, that law includes the law of evidence. Now, you may be amazed to know this, but sometimes my friends ask me what I'm working on. I mean, anyone hangs out with a construction lawyer, you'll know it's the worst thing to ask. But I told them all about the corroding pipework and the numerous experts and their competing theories as to what happened and why and what the likely cause was and the likely remedy. So this friend of mine was absolutely horrified and said, well, how can you possibly decide that? I mean, you weren't there. You weren't there when it was installed. You don't know what the problem is. You can't see what's happening inside the pipes. And I said, no, I absolutely agree. I don't have a crystal ball. Many people think an adjudicator does, but I don't. I don't have X-ray vision. I'm not Wonder Woman. What I do is I decide it on the evidence. I take the experts' theories. I look at the factual evidence. I see if it's supported on the balance of probabilities, more likely than not. So my friend then suddenly decided that my job was not the marvelous job they thought it was. They said, but you're just basically doing a jigsaw puzzle. And I said, that's absolutely right. I am basically doing a jigsaw puzzle. And if you are a party to an adjudication, give the adjudicator the bits of the puzzle that they need. Give them the evidence so they can put the picture together. And when you're doing that, remember that what you write in your submissions is not evidence. The person who's writing the submissions, the referral and the response and the reply, they weren't there either. They don't know what happened. As far as the evidence is concerned, it's the contemporaneous documents that the adjudicator wants to see. And if the facts that they're relying on are not evidenced by those documents, then you're going to need a witness statement to demonstrate the facts. And that witness evidence has to be relevant and it has to be admissible. So if the witness joined the project after the dispute arose, chances are their evidence is irrelevant. If it deals with matters that are not disputed, it's not necessary. If they're sharing their opinions of what did or didn't happen, irrelevant. If it regurgitates what someone else has told them, their evidence is worthless. Now, in an arbitration, admittedly, a key witness started their statement with, in my opinion, these proceedings are a complete waste of time. I thought, well, that's interesting. You started them, and I'm not interested in your opinion. And more damaging still, part of this claim included a lot of time that this witness had spent dealing with the disputed, the contractual problems, come in to sort out the problems, and a big slug of money was being claimed for his time in doing so. Funnily enough, his witness statement made no mention of the time that he'd spent or done. The quantum expert was unable to allocate his salary to this dispute, and he failed to prove his case. So it's important what you say, it's important what you don't say. If there's a big gap in the evidence, it can be just as revealing, and either way, it doesn't prove your case. Could I have the next slide, please? If your dispute requires opinion evidence of technical processes like the corroding pipework, you'll need expert evidence. Remember, experts give opinion evidence, which is based on the facts. Factual witnesses can't give expert evidence as a rule, and experts cannot give factual evidence. They weren't there at the time. Things go badly wrong if experts try to recreate what might have happened on the facts. You need the factual evidence and you need the opinion evidence based on it. If your dispute requires expert evidence, both parties are going to need time to consider it and to respond, and your timetable will need to allow for this. All dispute resolution processes involving expert evidence benefit if the experts are able to meet to discuss their respective views and decide what they agree and what they don't agree. The adjudicator then decides what remains in dispute. Sometimes adjudicators appoint their own expert, tribunal appointed expert. I have done that. I find it works very well, but the parties will still want to see what the tribunal appointed experts' opinions are, and they will want to comment on it quite fairly. And again, the timetable should allow for that. Next slide, please. As we saw, adjudication tends to be a documents-only process, so the documents are absolutely essential to a successful outcome. The more accessible and logical the documents are, the easier the adjudicator's job is. Remember, we want to make the adjudicator's job easier. They're much more likely to pick up on the subtleties of your argument if they can find where it is. They can find the documents in support. If the decision-making process turns into something like wrestling with a many-headed hydra, the chances are the adjudicator will miss the point, and even if they find it, the cost of the process will be much increased. Don't present the adjudicator with a dog's dinner and ask them to pick the bones out of it. Jumbled documents waste time. If you can present the documents paginated, indexed, cross-referenced, in chronological order, then the adjudicator can find that document that they want without sitting there saying, I know I've seen it somewhere, and ploughing through the 20 files to try and track it down. When an adjudicator comes to write their decision, the chances are they will have at least 4 sets of submissions in front of them. If we go back to our jigsaw analogy, the adjudicator would like to know where to look for the pieces of the sky, the garden gate and the orchard and so on. If you can make that job easier for them, it will be to the benefit of all. Unfortunately, Bill asked me to describe the perfect referral. The truth is, much like the perfect job or the perfect house, or perfect partner, they just actually don't exist. But here are some common pitfalls that I come across time and again. The first one is really quite surprising, that the submissions identify a key document, a method statement or something like that, and everyone agrees it's the most important document, everyone refers to it, but blow me down, it's not in the bundle. The second common thing is it is in the bundle, but what everyone's been referring to as the method statement is actually called Schedule 22 as amended, something like that. So it's misdescribed and you can't find it. Or it's in the bundle, but it's been hidden amongst the authorities because the request to put things in chronological order was taken a bit too literally, so the authorities are included in chronological order with the contemporaneous documents. Another common problem is the tabs don't correlate. Tab Appendix 22 is behind tab 23. Appendix 54 is behind tab 55, and this goes on for 180 tabulations, and that's because right at the beginning the submissions went behind tab 1 and put everything else out of kilter. Another common error is that the submissions were drafted by someone and the documents were put together by someone else, and no one checked what went out. So the submissions just actually don't tally with the documents. And then I am presented with indexes which tell me where the appendices are, but not what's in them. So again, I have to prepare my own index in order to find the documents that I'm looking for. Could I have my next slide, please? This is precisely what I'm talking about. Here we have an adjudicator starting the process of writing their decision, rolling up their sleeves and getting on with it. They tackle the job and at the end it gets the better of them. Jumbled documents end badly. Next slide, please. Another important feature of adjudication is what are the issues? Now, the issues are the matters that are in dispute that you are asking the adjudicator to decide. They are the questions that you want answered. And in formal dispute resolution in court or arbitration, those issues are defined by the pleadings. Pleadings get a bit of a bad press because they can be very lengthy and the process of producing them can be very time consuming. But at the end of it, you can look to see what's alleged, see what's admitted, see what's denied, and what's denied is in issue and needs to be proved with evidence for the tribunal to decide. And in adjudication, there is no process for defining the issues. Parties exchange their submissions, certainly, but they tend to major on their strong points and brush over their weaknesses. And so it wouldn't be unusual at the end of the exchange for the adjudicator to think, well, what is it I've actually got to decide here? Now, well-advised parties ought to be able to agree what the issues are at the end of the process, of the submission process. That's not to say they agree what the answers are, that's for the adjudicator, but they can agree the questions. Agreeing the issues is not a sign of weakness. If it's not possible to agree them, at least the parties can submit their own respective list of questions. It then leaves the adjudicator to decide what the issues are, and they may not tackle that task in quite the way that the parties had intended. Now, parties might say, well, look, it's in my adjudication notice, which says, is the referring party entitled to relief claimed? That's a question, isn't it? Well, it's a question, but it doesn't tell me what the underlying issues are. What are the matters that are in dispute? What is it that needs to be decided? And along with the jumbled documents, adjudicators can be presented with a jumble of issues as well, saying things like, well, can you tell us what the contract says, or whether it says this, that, and the other, which provisions of your decision then apply to our claim, and then can you tell us what our financial remedy is? Those are not issues. That's more like instructions to leading counsel. You need some answers as to how to present your case before you commence your adjudication. Next slide, please. So the submissions, this is the submission documents for the referral and the response and the reply. It's what, when the adjudicator comes to write their decision, it's going to be what they're going to be looking at before they tackle the evidence. It's usual, as I've said, to have 4 sets in front of you. They are open, so you can't see. You don't have the front page in front of you all the time. So it's really helpful to identify what they are on every page. Use headers, use headings so that the adjudicator can find the particular areas that deal with the particular disputes. If you have an extensive dispute, I've had one with 60 issues to be decided, would be nice if there was a heading for each of those. Index it, cross-reference it, and try to avoid, if you can, TLAs. Now, we all know what TLAs are, especially if we're watching Line of Duty in the UK, where they love an acronym. And the more obscure the acronym, the more edgy the drama. Incomprehensible acronyms do not help the adjudicator. If you're going to use them, please provide an index to explain what they mean. 3-letter acronyms, avoid them, please. Now, as I've said, your referral, the referral Your notice, adjudication notice, is the key document for defining the dispute, but the referral is the one that should include all the ingredients of your claim. It should have your cause of action, if you're alleging breach, causation, damage, it should all be there. All the documents should be there, nicely paginated. The evidence that you need should be identified. If you've got a knotty quantum, it should all be particularized. And I do like, I know that the car analogy is used for dispute resolution, where parties believe that litigation is a kind of Rolls-Royce of a vehicle, and that arbitration is the low-slung, bulletproof, dark-glassed international limo, usually with 3 steering wheels for each of the tribunal members. So what is adjudication? Well, someone said to me, oh, it's like a little sports car, and I thought, no, it's not. It's more like a camper van, because you can take it anywhere, you can go anywhere, you can go across rugged terrain, you can stick to the low roads if you like. It's super flexible, but you do need to pack it up with everything that the adjudicator needs, so that when they're up their mountainside unpacking their camper van to light their fire and settle down to write your decision, you need to make sure they have everything they need. You don't want them to be in that position only to discover that there's no tin opener. A little known statistic is that 30% of adjudications end in a nil value award. Now, some of those are declarations, but they account for only 10%. So 20% of people don't get what they ask for. If you want to avoid being one of them, remember you need a reasonable timetable, you need to define your issues, order your documents, make your submissions accessible, and ultimately, my final slide, please. You need to be nice to your adjudicator. Thank you very much. I've really enjoyed that. I hope you have.
Thank you very much indeed, Kim. And I think that, Caitlin, if you can just put everybody on view, that would be good. I sort of remove the slides. Yes, I think that working out whether your adjudicator is a man or a woman and just addressing them in whatever form they want, whoever they are, is a basic step. And getting documentation. I recently had, I think I said to Kim, an adjudication where the dispute was about 150,000. The submission was something like 100 pages, and there are thousands of different documents. And it was, I was responding, it was a nightmare. I have got some questions, Kim, but I'm going to start with Gabriella. So, what do you see, Gabriella, as probably being the most likely projects that are going to take place in Hungary in the next, say, year that would afford opportunities for other people?
A lot of new projects. We are really active, also our firm, and the country is active with new investments and extensions of existing investments as well. For example, GE is expanding in Hungary, IBM as well, Lego, the toy manufacturing company, certain Korean companies, Dosan, SK Innovation. The government is, as I said earlier, is really active and gives a lot of subsidies and other allowances for investments. And I think we have good expectations, even if the BMW was stopped last year due to the pandemic, but we all know that it had other reasons to do so. All other investments are really active, and we have good expectations.
And do you think that Hungary has enough? You know, I won't ask about lawyers. Do you think Hungary has enough construction-related consultants, architects, engineers, quantity surveyors, or do you think there's scope for them as well in terms of projects within Hungary?
No, that Hungary doesn't have enough skilled workforce and blue-collar workforce either. So we do need to hire workforce from everywhere over the world.
Oh, well, there you go. So opportunities for everybody.
Yeah.
So for Kim, just before, so I'll see if there's any more questions in the chat. Whilst I'm having a look, how do you think a party should identify issues if the other side isn't agreeing? What in what would be your sort of top tip to people?
It's a very good question. So first of all, there is a bit of a misunderstanding, misapprehension that somehow agreeing something with the other side is a bad idea, and this is it's an intellectual process. Agreeing the issues, it ought to be possible. So if it can't be agreed, then there's something not quite working. That said, I mean, I have seen parties exchanging endless drafts where they cross each other's proposals out, and the idea isn't that it should create satellite litigation. If they can't agree what the issues are, they can't agree. So the best thing then is for them to each set out their own respective version and then leave the adjudicator to decide. But it will become an issue in the adjudication as to what the issues are. As I say, it's unfortunate, but sometimes necessary. Can I just say, someone's commented in the chat and made a very important point, which is, isn't Kim a man's name? Well, I've got something to say about that. No, when I was growing up, it was a dog's name. And everyone would say, oh, we had a dog called Kim. That was very common. So no, it's a dog's name, but it's used by men and by women.
Well, I'll let you slap. I'll let you give Peter a slap on his own. Can I just say, in terms of adjudication, I think I was admonished by a certain TCC judge many years ago for conducting litigation like warfare. Now, I'm not sure if that was actually a compliment. But do you think that the increase in more lawyers, Kim, is because adjudications are becoming less about just money, less about purely, say, the non-service of pay less notice, and as Paul has just said, you know, negligence claims? Do you think that the claims are becoming more complex in adjudication, and hence the increase in lawyers?
Yes. Well, I've been around long enough to remember when all this started, and Sir Michael Latham introduced adjudication. It was a one paragraph in his report about construction procurement, and it was very much an off-the-cuff idea. But he was clear in his mind, at least, that adjudication was intended for on-site disputes only. And the idea was that construction professionals would go to site to see what the problem was, have a site meeting, listen to both sides, make a decision, produce a short memorandum, and lance the boil of dispute. Now, when the legislation got into the hands of the government, and they very wisely put a qualified biologist onto the job of drafting the statute, they said that adjudication could be brought at any time. And this introduced the idea it could be produced long after the dispute was finished. I mean, after the project was finished. And the vast majority of adjudications that I see, it is long after the project is over, when there may be some really quite serious issues which are stopping the parties from closing out the project and finalising the final account and so on, and they do need an answer to that.
Yes, I think that's right, and I think some of that is perhaps due to over preparation of claims by lawyers. Unbelievably, lawyers being too verbose. Who would ever have thought of that?
No,
I know that actually I'd claim that to obviously be older than you, therefore, because I can remember doing adjudication through DOM2 contracts, where I actually think DOM2 was the birthplace of adjudication and not Latham. But I don't know if Donald is still there. I know he emailed me a question the other day, but I've obviously in my negligence, I've managed to leave it on my emails, which are turned off, because otherwise the pinging noise would distract you all. So I don't know if Donald, you'd like to address Kim yourself, and then whilst Donald's doing that, do any of you have any other questions for Gabriella? If you want to put them in the chat, and I'll come on to those next. Donald, you're muted.
Thanks, Bill. It wasn't specifically a question about adjudication. It was a more general question just about the law of evidence in England. I'm assuming that it's essentially a common law as opposed to codified law, the way we have it in most of the states in Australia. But when I looked up legislation in England, I found there are about 4 or 5 evidence acts, and some of them going back to the 1800s. I wasn't sure whether they were all still valid or not.
I'd say that's one for Bill, really. But the intricacies of the law of evidence tend not to apply to civil disputes. They're to do with criminal jurisdiction, where it's important that juries aren't misled by. It's very important that the evidence is focused on the particular allegation on the indictment, because juries the system doesn't have the confidence in juries that it does in High Court judges. So, I mean, it's been a very long time since I've been involved in any argument about whether evidence is admissible in a statutory sense. Much more common as to whether it's actually relevant and therefore admissible.
Yeah,
and there's a lot of woolly thinking on that front at the moment.
Don't let your witnesses lie, and there's a whole load of new rules on evidence within what was the construction course in the UK, in England, whereby solicitors are no longer, we're not meant to be writing witness statements anymore, which is obviously a ridiculous statement, because how could we possibly not be writing the witness statements? But basically, you need to have a statement of truth on your witness statements. You need to have, as Kim has said, witnesses who actually give evidence of the stuff that they were directly involved with. I see so many witness statements where it's just so much verbiage, and if you cut it down and persuade your witness to restrict themselves to salient facts on which they can give direct evidence, it actually makes your case stronger in a shorter statement than having a long statement that you have to read through to extract really specific points. And yes, someone said good records are strong evidence for claims. They are, and even more so if you can get the person who produced the records to give a witness statement and to say, here is the document. I prepared the document on this day. These were the people present, and this is what happened, as opposed to somebody referring to very generalized documents. So evidence does differ, but I would say evidence the world over doesn't differ, in that whatever the rules of evidence, you need to have people who were effectively there. They make short statements sign a statement of truth, which gives you confidence in the statement they're giving. And just as Kim said, you know, set your evidence witness statements out. I mean, it's not difficult. Even I can format a document. In my view, judges love statements to have gaps, paragraph numbering that is actually correct, cross-referencing to documents. As Kim said, frequently the referencing in a paragraph bears no relation to the bundle. I can't understate the value of spending time checking and rechecking that any point you claimed in your referral actually has a statement to back it up in the witness statement, and that things said in the witness statement actually relate to your claim. It makes it preparation. You don't have to have a lawyer, but it does really, really assist you. While we're on, how many, do you want to put in the chat, how many people are perhaps engaged in an adjudication? Obviously, don't give details. How many of you are actually engaged in an adjudication or at the moment? And how many of you are engaged in a large project, either within your country or in another? I'm interested in terms of, given the pandemic and the up and down nature of work, how busy sort of people are around. Yes, good records. Okay, Colin, you're involved in both. I've certainly seen an increase in interest in projects. While I'm on, I'd very much love an introduction, if anyone has one, to someone within the World Bank. That'd be interesting. If anybody would like introductions to anybody who's been on today's webinar, do email me. You should all have my email address from logging on. And I say tomorrow, everybody will get an email and you will be able to log on and download the slides, presentations, and more information from today. Can I just go back to Gabriella? You talked about the fund manager, and it has a ceiling level of contract value that was quite high. Is it an expensive process to set up? You said that's the obligation of the employer. Is it, very expensive or what?
It usually has a fixed cost for the client. So banks do not, or financial institutions established for this purpose do not give the price for transfers like in a usual bank transfer or a usual bank package. But for a project, and for that it is usually a fixed price independent. So it doesn't matter how many contractors or subcontractors are in the project, but it's a long-term procedure to have a project and a long-term relationship for these parties. So it's a couple of euros per month, I would say. It's the typical price.
Because I think that is something that I could certainly see the benefits of being used, and there are similar things, but the flow of payment is still an issue. Sorry, I'm English. Here you are.
No,
I wish I could. How do I pronounce your name?
Oh, it's an Arabic name, Hussein, but in French we say Lausin. We could be
Lausin.
Okay. No, it's H.
Lausin. No, there you go. I'm right.
No
you
problem.
have a question, Kim?
Yeah. Thank you. First, thank you, Gabriella and Kim, for your presentation. I had a question for Kim regarding the threshold. If I understood, for adjudication, you have a panel of adjudicator per project, and you have to stick to this panel. Is it my understanding? Second, you have different adjudication regarding different questions that you ask you, so you can have 10 or 100 adjudications in one project. So when you sum them, you can have another figure, because here in France we have only one shot, one claim, so we didn't divide it like we are doing it in UK. This is why, because you say that you have a shareholder, to have a junior or new. So how could you bring a new one as you don't know what is the amount at the end? So how?
Yes. These are good questions, aren't they? Well, as a lot of contracts, when this process was new, identified the adjudicator in the contract, this seemed to be like a good idea until they discovered that when they went to the adjudicator that he'd actually died and wasn't available to do anything really. But also your point that you won't know what the dispute is when you sign the contract, and a lot of adjudicators were put into contracts without being consulted. They didn't even know that they were there. So some of the PFI schemes ask for a panel of adjudicators to be named in the contract from which the parties can choose as the dispute develops. And what tends to happen, again, in my experience, is that panel is named for the primary contract, but the various contracts down the line don't name them. So when the dispute comes up, you still have to go to an adjudicator nominating body for them to nominate the adjudicator. So I suspect that going to an adjudicator nominating body is a better solution for the parties, because by that time you know what the dispute is, you know what the value is, and you know the kind of person that you want. There are people who are dual qualified, so you have engineers who are qualified as lawyers. Sometimes they obviously want just a lawyer, sometimes they want a really very senior lawyer. I mean, anecdotally, there was a big dispute between the parties as to who they were going to have, and each time they upped the ante. So they went from a High Court judge to a Court of Appeal judge, ended up with Lord Neuberger. They couldn't agree on him, so they ended up with me. And I can't think what Lord Neuberger would have made of it. So you asked a number of points. Does that cover?
No, second one is thresholder. You spoke about. You mentioned that for the new adjudicator, you will put the thresholder.
Well, this is another interesting one, because a lot of these panels were set up when adjudication was first launched, which is 20 years ago. And some of the adjudicators were in their 30s or 40s. Of course, they're now 20 years older. And the panels have decided that they only have a certain turnover of disputes. So they haven't been recruiting. And what's happened is the age of the panel, because the Earth goes around the sun, the panels are they're full and they're aging. And there's a very real recognized initiative to bring junior people onto those panels, but it's proving difficult.
Yeah, it is difficult. I sit on the RIBA review board for adjudicators, and we've spent a lot of time reviewing adjudicators, and they have to go through a process of providing sort of 2 or 3 of the last decisions, and we interview them, and we try and maintain a high quality. But it's difficult to remove people from a panel, and as Kim mentioned, certainly RICS has introduced low value scheme, but a low value dispute doesn't mean to say it's simple, and it brings its own complexities, and therefore it's quite difficult to just presume that a newly qualified adjudicator is suitable to a low value account. And there's a lot of interest. I would say in the last year or so, a lot more people have taken up the thought of becoming a full-time adjudicator. I think one of the other questions I think asked there was the number of disputes. So in England, you can only refer one dispute at a time to adjudication, and there is within that legal arguments as to what is the dispute, so how is that defined, but you can bring as many disputes as you like during the course of a contract and afterwards. So there is no limitation, save for, as Kim mentioned, the Earth moving around the sun and what have you, as to limitation period for the number of disputes. So it's unusual in that sense. It doesn't really perform the operation that it was originally intended, as again Kim said, as being an immediate method during the course of a contract. And I think that, to a large degree has passed more to dispute avoidance boards. Adjudication is still very contentious. It is actually, it's quite difficult to agree an adjudicator. It's the same as mediation. I guarantee if I give 3 names to somebody, they'll be rejected simply because I've given 3 names. And it becomes a childish, in my view, childish game. I'm not going to put forward 3 people that are, are my relatives, because it wouldn't be allowed, or that I somehow think are going to favour me. I put forward the names of people that I respect and trust, and yes, I probably will have used them. It is highly unlikely that a party won't have either instructed Kim as counsel or had her as an adjudicator on the matter. So the fact that you have some prior knowledge really shouldn't be a point for disagreement. But unfortunately, parties, that's the whole nature of construction. It is very contentious. Sure. I don't know if anybody.
From my understanding, adjudication is you mix the 2 bodies, which is dispute board and the arbitration. You mix them, so you have only one body, adjudication. That's it. You have they follow you during the project. You bring them all your matters, and it's binding. What they say is binding, and that's it.
It can be used that way, certainly. I've been on a PFI panel of 3 of us for a project which was open warfare, and over a 2-year period we gave 18 decisions between us, because there were a lot of PFI is designed on a collaborative basis, which is great when it works. It's a bit like a marriage, really. But my goodness, if it breaks down, it is a disaster. And so they needed everything to be decided for them. And we were, there was me and a solicitor and a quantity surveyor. So we were quite a good team, took it in turns to decide these serial disputes.
Frequently, taking that point, I'll bang on about it. Not enough time is spent at the start of a contract to discuss its terms. I think you should have a good argument at the beginning when you're discussing terms, because invariably it flags up the bits that your client or the other side either just don't understand or didn't actually realise that they were taking on liability. And then you can work collaboratively. Unfortunately, everybody presumes that you're all going to be sitting around the fire singing Kumbaya, and then when things break down and they all go a bit Pete Tong, people then are surprised by the cost. I can certainly assure everybody, litigation in the UK is very expensive. It's front loaded, and it probably is overall, possibly not, perhaps not 10 times more expensive than adjudication, but a lot more. We have a very complex set of procedures that must be followed before you can take a matter to trial. So those are compelling in terms of time and cost to comply with. Does anybody have, I'm conscious of the time, does anyone have any last questions for either Gabriella or Kim? So does anybody want to ask them anything else? Just checking I haven't missed any questions.
Yeah, I would have a question to Kim. As a person and as an adjudicator, how many cases can you handle at so in parallel, and how is your life?
How's my life? Oh, thank you.
Professional life.
That's a short one. No, that's a really good question. Well, this 28-day timetable, you can imagine when it first came out, because there's no rule book for adjudication, it really was a bit of a free-for-all. And this is why I believe that getting the case management right at the outset is to the benefit of all concerned. But I put in my terms and conditions that I am allowed 7 days from the date of the last submission in which to produce my decision. If it's a really, really nasty looking one, I make that 14 days. I'm not alone in this. Some more experienced adjudicators ask for 3 weeks, which I think is a bit over generous. But that does mean then that I know I need a clear week in which to produce a decision. So the parties can swap their submissions, have all their arguments about jurisdiction and what have you, but I keep that week free, and then I'm available for another one after that. Doing more than one at the same time is not to be recommended because it's quite an intensive process. You can do other stuff, but you cannot, as I say to my clerk, you cannot write 2 decisions at the same time. That is physically possible. Because it is basically quite a high turnover process compared with litigation, which usually is 2 years from beginning to end, or arbitration, which is often longer. The work is extremely interesting. You just never know what it's going to be next. And even if the project sounds a bit dull, the dispute can be very interesting, or the other way around. And even if it's very, very demanding, it's over within a short time. So, but I wouldn't want to be someone who does nothing but adjudication. Because although I urge the parties to be nice to their adjudicator, very often they're not. So they can be quite short, it can be quite rude and unhelpful, and it can be quite wearing if you do nothing but adjudication. Also, you get a bit jaundiced, I think. So a good
how shocking that anybody could be rude to you, Kim, and that's just utterly appalling, as he says, cutting across you. And being rude to judges and adjudicators or arbitrators is surely only practiced by people who have a short life expectancy.
Well, advocacy is the art of persuasion. Let's not forget that. And although it's a documents only process, you are engaging in advocacy. You're trying to persuade someone to find in your favor. So
yes, and so don't forget that. Well, fantastic. Thank you all very much for attending. May I also just have a small plug? The 20th of May is our next webinar. I'm pleased to say we have Lucy Garrett, QC, speaking, and also John Caruso. John Caruso is based in Adelaide. So we have, again, a nice international feel to the matter. If any of you have any other questions, please do not hesitate to email me and we'll deal with those. If anybody would like an introduction to anybody you've seen or perhaps not seen, but you've just seen their name, let me know and we can email them and see whether or not they would like to be introduced to you. I think that's the GDPR approved way. If tomorrow you'll get an email, please download the information. As I've mentioned, it would be lovely if you'd like to say equally something lovely on LinkedIn. Please use the hashtag BL webinar. You can look at all the previous webinars. They're downloadable from our YouTube channel and on our website. Finally, I'd like to say a huge thank you to Kim and Gabriella. I'm sure you can all appreciate just how long it takes to prepare slides and information and to provide us with real information, real advice that is actually actionable rather than just some sort of highfalutin nonsense. So I'm really grateful for Kim and Gabriella because it's lovely to have such great presenters who provide really valuable information. That just leads me to, say to you all, thank you for coming. I appreciate that you're all in, different time zones. So I hope you have either lovely days, evenings, and that if you're working all day, that your tea and coffee is tasty, and if you're somewhere like Donald, that it's a nice cool beer perhaps, or a glass of lovely wine. Thank you all very much for attending. Again, big round of applause to Gabriella and Kim, fantastic. And we'll see you all again very soon. So take care, everybody. Bye.
And thank you, Bill, for what you are doing also.
Well, if Gabriella and Kim, thank you again for being here, your time. Gradually, you'll find that people will just sort of disappear, but sometimes people pop out and ask questions. Alfonso is still here from Rome. I'm really grateful. I thought it's really interesting. I'm fascinated by what is going on in different countries. And I love some of the buildings that you showed in Budapest, Hungary, because Budapest is such a diverse city, in that you've got from the ruined bars and the Jewish Quarter to the islands, and then I've been fortunate enough, it's a couple of years ago now, on the other side of the river from the main town city hall, which is one of the biggest in Europe, isn't it? I remember.
Yeah, the castle.
To the other side of that, you've got a number of spas that were being done up. So it truly is a lovely city, and very, very different yet similar in London, some of the ways. And Kim, thanks for providing, just real tips, because I think people just forget that there's so many things you can do to improve your prospects. So I think it's helpful when pardon me if I use the expression horse's mouth.
I thought Gabrielle's slides were wonderful, and I love that zoo. That just is going to be so fabulous when it's done, isn't it? It's really, really, really interesting.
I love seeing new buildings. I love it when you see sort of the shell or a frame of a building, and then when you see the end result, it's cladding nowadays and things like this. It can just be so radically different what we can do with space. I mean, 20 years ago, I was working with clients, and we were building cantilevered football stadiums, and that was sort of cutting edge for that time, for the extent that the steel could lean over the pitch. But now you look at self-supporting glass structures, and for example the zoo with the curves, and it's amazing.
And getting all the planting in, that's really that's an innovation, isn't it, to get more greenery actually incorporated into the construction.
And then of course people get it wrong, because the more complex the building, the more likely it is to go wrong. So happily so there's no end of disputes. But well, again, thank you both very much.
Thank you for the invite. I do have to go now, but it's been a real pleasure. I'm going to
close the call. And
very interesting.
And thank you, Caitlin, for looking after us. And I'll speak to you both soon. Okay.
Okay.
Cheers, Alfonso.
Thank you.
Bye.
Bye-bye.